Thank you. Thank you, ladies and gentlemen, for all of last week, your attention to this case and your patience as we put forth to you over 400 exhibits. That's a lot of evidence, a lot of exhibits. On behalf of the state of Tennessee, we thank you. On behalf of the Christian Newsom family, they thank you as well for your attention last week and your very thoughtful deliberation that you're about to engage in. Having said that, this is the time of trial where we get to talk about legal concepts that apply to the facts that you've heard from the witness stand and through all these exhibits. So I want to kind of start maybe where we started last week. Before we do that, the judge is going to read to you here in a minute a set of instructions that are about that thick. And they're real long. He's going to read every word to you. You're going to get a copy or copies to take with you back to the jury room. But I want to kind of give you a preview of what some of these instructions say and some of the definitions that they give you. The way the instructions are laid out, they will define the crimes that are set forth in the indictment and give the definition of those crimes and the elements of those crimes. They will also list underneath each of those crimes what we call lesser included offenses. And a lot of these pages of these instructions are dealing with those definitions of lesser included offenses. So one of the things the judge will tell you is that the first thing you got to do is consider the charges that are listed in the indictment. Okay? I hope that makes sense to you. And he will further instruct you that you cannot proceed to consider any of these lesser included offenses unless you find Mr. Floyd not guilty of the greater offense. The greatest offense followed by, depending on how you go, okay? So I just want to point that out to you. A lot of these definitions are definitions of crimes that we call lesser included offenses. But the main thing is to consider the crimes charged in this presentment. And I don't think we're going to have really any issue about what crimes were committed against these two young people, okay? So having said that, we have to prove two things to you beyond a reasonable doubt. One being the elements of each crime charge in the presentment. We talked a little bit about that last Monday. I think General Fitzgerald maybe went over some of the elements of some of these crimes. We have to prove those to you. And secondly, we have to prove that this defendant is responsible for the crimes that we have proven to you. Okay? It's responsibility and elements. There are two types of evidence we brought before you: direct evidence and circumstantial evidence. And again, some of these terms that I'm going to throw out, they're terms you may not be familiar with, but as we'll explain later, the concepts behind those terms, I think you'll be very familiar with. And I think you'll see what I'm talking about when we get to it. The direct evidence is the testimony of a person who has perceived by their means of their senses the existence of a fact sought to be proven. That's where you actually see, smell, hear certain things that are important to how you decide the case. That's direct evidence. We presented some of that to you. Let's talk about Xavier Jenkins. He saw a lot of activity at that house at 2316 Shipman Street when he came to report to work on January 7th, early morning hours of January 7th. He noticed the lights on this 4Runner that was parked in front of the house, and he identified specifically by the picture Shannon Christian's 4Runner parked in front of 2316 Shipman Street. And also that he identified the Pontiac Sunbird that was tied to this defendant parked directly behind Shannon's 4Runner at 2316 Shipman Street. At the time he came and saw all this commotion, this activity that was unusual at that hour when he had reported to work. A little later on, he saw 4 black males riding around right in front of him in that 4Runner. And we know from this proof that there are 5 individuals in total involved in these crimes that occurred at 2316 Shipman Street. Adrian Mathis, you just heard from the testimony that was read to you, where she had testified that this Sunbird that was very specifically identified by Mr. Jenkins, this very Sunbird, she loaned to this defendant the weekend of January 6th, 5th, 6th, through the 8th. And the next time she saw her Sunbird was on, I believe, the 9th, broken down in front of this defendant's aunt's apartment. in Ridgebrook, where this defendant was obviously known to be because that's where he was later found to be on January 11th. And that she found a bag of bullets in the car and she threw them away. And so this car that is tied specifically and directly to him, parked behind the 4Runner at 12:30, 1 o'clock in the morning on January 7th, is this defendant. He is the fourth black male that is involved in the activities and crimes being committed at 2316 Shipley Street. And we have Mr. Thomas, of course, as well. He saw this defendant with that Sunbird. He told that to Sheriff Jones in his interview, and told you here as well under oath. Specifically, he saw this defendant bringing a bound and blindfolded victims into the house at 2316 Shipley Street. He saw that happen. That was out of his sense of sight that he witnessed it. Not only that, but he saw this defendant, Mr. Boyd, take Chris Newsom to the railroad track, load him up in the SUV and the 4Runner, and take him to the railroad track. And while he refused to get out of the car at Mr. Boyd's request, he sat in the car and he told you he saw with his own eyes 3 flashes that he thought was from a gun. He, after that, saw this defendant get a gas can, which was in the 4Runner, heard a whoosh of gasoline ignite. And then that word whoosh is interesting because that's the same word Laura Hodge used when she described what's happened when you set something that's been soaked in gasoline on fire. Whoosh. He heard that. That was with his own senses. He heard that. And after that, he heard this defendant tell Davidson when they got back in the house, it's done. After Chris is killed, there at the railroad track. So that's direct evidence from some of these witnesses that you can consider. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove fact in issue, but one from which that fact may be logically inferred. And there's a whole lot of circumstantial evidence. We've got direct and circumstantial evidence. Here's some of it, okay? This defendant was the only one of these 5 people that had a car. You'll recall from the testimony that these folks came down from Kentucky. They had a ride down here, but that fell apart while they were here. They didn't have a car, except this defendant had a car. He is the only one of the 5 that had a car on that weekend, on that Saturday. He's the only one that had access to a car. None of them had any money. You remember that testimony. They had a bit of money. Don't forget the fact that there were multiple guns recovered, even including an assault rifle in this house, and 2 small caliber guns. We know there's another gun out there because the murder weapon hadn't been found yet. There were multiple gas cans, one in the car, the Sunbird, one in the Sunbird, and 2 or 3 inside the house that were also recovered. And we know that gasoline obviously was used in the attempt to destroy the body of Chris Newsom. Condition of the bodies. Ladies and gentlemen, you have seen images you cannot unsee. And that's just unfortunate. But you have to have seen these images in order to understand the gravity and the depravity of the crimes committed against these 2 young folks. I'm not going to show them to you again. You see them, you can't unsee them. You'll remember them for a long, long time, I'm quite certain. But these bodies, you saw the condition these bodies were in. That's circumstantial evidence of the effort that it took, not by 1 individual, not by 2 individuals, not by 3 individuals, but by 4 or more individuals to do the damage that was done to these young bodies. Don't forget, DNA is kind of a hybrid sort of thing. We can make the argument it's direct evidence, or we can make the argument it's circumstantial evidence. Either way, we got 4 out of the 5 defendants' DNA found throughout these scenes, if you will, inside the house. Of course, Mr. Davidson, Mr. Cobbins, we know where their DNA was found. We'll talk about that, and then don't forget Ms. Coleman's DNA was found on some of this evidence as well. And this defendant's DNA was found on the empty holster of a gun that has yet to be recovered. We say goes with that holster. Inside the sunburned car that he had borrowed from his cousin that weekend. The only car available, obviously, to give transportation to these individuals before they were the car stolen. In the location of the DNA, of course, we had DNA inside Miss Christian's mouth, her anus, her vagina. That's strong circumstantial evidence of the crimes that were committed. Don't forget about the attempt to destroy evidence. Bleach, referred from the TBI folks, bleach that's found spilled on top of Miss Christian's camisole. And some of the other bleach that was found. And what that tells you, of course, is an attempt to destroy the DNA in her mouth. Bleach coming out of her mouth, dripping down onto this camisole. That's one way to view that. The attempt to destroy DNA, we know, of course, from the testimony that bleach can destroy DNA. And so that's what that meant. And don't forget about Mr. Boyd's assistance to Mr. Davidson after these crimes were committed in hiding him. There's one I didn't put there, but I'm going to mention it now. You'll recall that Officer Agent Kingsbury is the one that told, that Mr. Boyd told to the fact that he and Mr. Davidson had broken into an abandoned house. We say to keep from getting caught. So think about this as well. Miss Kamiatu, Mr. Boyd offered to take her and her daughter to the doctor's appointment, or dental appointment. Think about that for a minute. After these crimes were committed, his Sunbird broken down, they had to get rid of the SUV, they abandoned it, stripped the stickers off of it, left it over there near Chipman Street. Now Mr. Boyd doesn't have a car. Well, guess what he's got when he offered to take Miss Kamiatu to the doctor? A car. While Mr. Boyd, or Mr. Davidson's hiding in this house back on Reynolds Street. Fortunately, the police stopped them before. Use your imagination. You can drop them off the doctor's office and then gone with her car. Picked up Mr. Davidson and both. He had access to a car at that point in time because he's driving without a license. That's how desperate, if you will, he is to be behind the wheel of the car. He didn't have a license. Yet he's driving the vehicle on January 11th. So that's some of the circumstantial evidence. Reasonable doubt, I mean, that's, you know, and I know Mr. Fraser is going to harp on that as well. Prove everything beyond reasonable doubt. And judge will tell you reasonable doubt is doubt created by investigation of all the proof. And after such investigation, let the mind rest easily as to the certainty of guilt. Key language here, though, we believe, is that absolute certainty of guilt is not demanded by the law to prove any criminal charge. But moral certainty is required. So I want to give you kind of an example or an illustration of what we believe these concepts mean. Because they're, you know, beyond reasonable doubt, that's not a term we're used to, circumstantial, what's all that? Let me just give you a graphic that we believe illustrates these concepts. Imagine this case, as any case, is kind of like a puzzle. Imagine a jigsaw puzzle that you would get, but picture it this way: if you're working, you usually get a box, a jigsaw puzzle, and they got on the front of it what it's supposed to be. So you kind of got something to go by when you put the pieces together. Well, imagine a jigsaw puzzle where you don't have that picture on the front of it. So you don't know what it's supposed to be. You throw all the pieces out there and you start putting them together. Well, imagine this as well. Say maybe 500-piece jigsaw puzzle might be appropriate for this case. But imagine a bunch of pieces missing and you don't know it. Well, you still start putting it together anyway. You get down, find out you got 10, 15 pieces missing. Well, that's kind of what this is. You start out with a bunch of pieces and you start putting them together. Well, in this jigsaw puzzle that is obviously a gun, you don't have all the pieces around the gun. Right? Look at it another way. You get a whole bunch of pieces, but you got a bunch of pieces missing in the middle. Okay? Missing pieces in a criminal context, unanswered questions, if you will, always going to have that. Missing pieces in this case, by the way, that would be absolutely certain if you had all the pieces. But missing pieces, you know, if we had videotape, all that, I mean, in this day and age, we almost expect that. Video of crimes and crime scenes and videos everywhere, just to capture everything that happened. We don't have videotape. We don't have video. We don't have all the answers to the question, what happened during that 36 hours, if you will, from the time those kids were brought back to Chittenden Street until we know Miss Christian was dead inside that garbage can. We can't answer minute by minute, hour by hour, all the things that went on inside that house. We cannot give you a videotape of the actual stealing of the car, the robbery of these kids over at Washington Ridge Park. We don't have it. That's a missing video. But what we do have is enough pieces from all this evidence, direct and circumstantial, to establish that these crimes obviously were committed and that this defendant is responsible. So let's look at the crimes that were charged. The way they're charged, you've got 9 counts of first-degree murder of Chris Newsom, 9 counts of first-degree murder of Shannon Christian, 2 counts of special aggravated robbery, 4 counts of special aggravated kidnapping, and 12 counts of aggravated rape. And the judge will instruct you that you have to return a verdict as to each of these 36 counts. Okay? So that's, and you'll get those definitions and the instructions will guide you through that process. But I want to talk to them about how they happen in chronological order. Okay? The robberies happened first, that being the vehicle taken by force from Shannon and with Chris there. And then the kidnappings occurred, and then the rapes occurred, and then premeditated murder occurred, and then felony murder occurred. So, back to January 6th. Of course, we know that Shannon and Chris were at the Washington Ridge Apartments preparing to go to a party. Shannon had gotten off work early. Their plan was to go eat something and then go to the party. What else we know about Washington Ridge Apartments? That is an area, an apartment complex that Mr. Davidson is expected to be at in order to pay Ms. Freeman, Ms. Jones, some money for furniture that she had bought from her. So that's why these crimes started in Washington Ridge Apartments. Mr. Davidson is the one that has that connection to Washington Ridge Apartments. So Shannon and Chris are there. They're at that Forerunner in the parking lot. Meanwhile, back across town, several miles away, of course, at Chittenden Street, you got these 5 individuals at this house, in and out of this house. And they come up with a plan. And you recall Mr. Thomas said he heard Mr. Collins, I believe, say Mr. Davidson had this plan to do something bad. And the plan was to steal a car. Again, they didn't have a car. They didn't have transportation, didn't have money. So they come up with this plan to steal a car. Okay? Again, Mr. Boyd is the only one that's got transportation. Now think about it. Davidson and Collins want to steal a car. Davidson arguably selects Washington Ridge Apartments. How are they going to get there? It's miles away. They got to have some way to get there. Now, Mr. Thomas didn't tell you that Mr. Boyd drove them over there, but how'd they get over there? They didn't walk. We know they didn't walk. Because when they ditched the SUV, is on the down the block. They didn't ditch it 4 or 5 miles away and try to throw everybody off. So we say this, the evidence strongly suggests, the circumstantial evidence strongly suggests that this defendant was in it from the get-go. He provided transportation in this Sunbird to Washington Ridge Apartments for these other guys to steal a car. Now, give him the benefit of the doubt. Arguably, the plan was just to steal a car at that point in time. And they chose Washington Ridge Apartments to do that. And that's where they went. We say in Mr. Boyd's car, or the borrowed car that Mr. Boyd had, to Washington Ridge Apartments. Again, it's just a theft. Just stealing a car. Why does it take 2 or 3 people to steal a car? Somewhere along the way, the plan elevated from stealing a car to stealing a car by the use of force. To forcefully take a car from somebody else's possession. And that's the elements of robbery. And I'm not going to put all the elements up there, but I mean, that's what a robbery is. You take a property by the use of force. And we add to it a little bit more. We know there were guns involved. Mr. Thomas told you about all the guns, and you've seen pictures of all the guns from that house. So that makes it an aggravated robbery when you introduce a weapon to it. If you're going to steal a car, whatever happened to hot wiring a car? Okay, years ago, that's the way you stole a car, just hot wired. I guess these new cars can't do that anymore. And the easiest thing to do is just find somebody that's got the key, got the car running, or whatever, and take it by force from them. So that theft became a robbery at Washington Ridge Apartments. But it didn't stop there. They took that car, not only the car, but the individuals that were in it, or getting in it. That's what this proof shows. They decided to steal the bodies, if you will, and took it back to Chipman Street. And of course, we know there was a theft involved because this car was found abandoned and altered, the stickers removed from it, just a block or two down the street from where they were hanging out, this Chipman Street area. We know their property was taken because later on, of course, inside a trash bag, and I'm not going to show all the pictures of all the items that were stolen out of this car that belonged to Shannon, Christian and Chris Newsom, but you've seen the pictures. Their property ended up in trash bags at 2316 Chipman Street, in the area of town they would never have gone to. Chris's hats, of course, the Tennessee hats, and all the other items that were laid out, and all the other pictures that you've seen of the property of theirs that were stolen, including property of theirs that made it all the way to Kentucky. This Christian's property made it all the way to Kentucky in a closet inside a hot water heater. So at this house at 2316 Chipman Street, here they come. They have now stolen a car, which is a nice car. They've got 2 kids that were trying to go to a party at 9 or 10 o'clock on that Saturday night and be with their friends after they've gone to get something to eat. Normal Saturday night young adult activity. And no idea what was coming. They get forced into their own car, and that car is taken back to this house, and they are marched into that house, and there's the kidnappings. So we've gone from the theft of a car to a robbery, to an aggravated robbery, to kidnapping. Kidnapping is removing somebody without their permission and taking them to some other location. And that's what kidnapping is. And we know they were kidnapped, of course, because Chris Newsom's body was found bound and gagged on the railroad tracks after it had been set on fire. The bindings and gagging, of course, is associated with kidnapping. And of course, inside the house, this Christian's body is found inside this garbage can. Again, Mr. Thomas told you that he saw this defendant bringing, along with copies of Davidson, these victims, bound and blindfolded into that house, marching them into that house. This defendant, that's his actions. And he saw this defendant get into that forerunner with Chris. After not too long having been there, and in the timeline, of course, we know that Chris was shot about 1:45 in the morning. But you also know before that, within an hour or two before that, he was brutally raped. And this defendant took him to the railroad tracks. So now they've got the car, they've committed robberies, they've committed kidnapping. And you know where I'm going with this. You know what the inevitable is. You know, once you've done all that, you know what they're going to do. Eventually they're going to kill them. It's sad that they probably do that too. Go kill them. But before they do, they're going to brutalize them some more. They're going to rape them. Chris was raised table, probably some object. Because he had, you seen the pictures of the injuries to his ankles? This Christian vaginal area, what trauma that she suffered through that area. To the torn frenulum in her mouth, which is associated with forceful penetration to that area. And of course, the DNA that was left in her mouth that couldn't be washed away by bleach. Her vaginal area, and her penis as well. DNA of these team members, if you will, of Mr. Boyd. And of course, the inevitable is murder. We know the murders were committed because Chris was shot 3 times, once in the head, 2 in the back, a fatal headshot. And while alive, Shannon Christian was placed, tied, you see how she was tied up, and placed into that garbage can while alive. And she died of what Dr. Lucian told you was positional asphyxia. Because of her position in the garbage can, she couldn't breathe. She eventually died because she was suffocated from being unable to breathe by being folded into a garbage can. Again, Mr. Thomas told you, he saw this defendant take Chris to the railroad tracks, saw 3 flashes from the gun. Now, let's talk about this. Those are the crimes. Now, I don't think this Prater is going to argue that these crimes are not committed. Let's talk about this defendant's responsibility for the commission of those crimes. It comes in three legal concepts, if you will. Criminal responsibility definition, and part of that being this concept called natural and probable consequences. And lastly, the very definition of felony murder. We're going to talk about each of them. Criminal responsibility, you know, it's going to be some legal type language, but I ask you to think about it in more simple terms. And it's a concept I suggest to you that we're all familiar with. From growing up, from being taught as youngsters, I mean, our parents have told us growing up, be careful who you choose as your friends, because your friends can get you in trouble. I don't know how many times I heard that growing up. And I won't tell on myself, I'll give you an example. When I was in high school, 50-something years ago, I had some buddies that back in the day, you like to pull pranks on your buddies, okay? And one of the pranks that was real popular back in high school was roll somebody's yard with toilet paper. Now it's so expensive, I guess you can't do that. But I was talked into doing that with somebody, and I think I was probably 16. At that time, he could drive. My job was to drive to his buddy's house a couple of streets over, let these other guys out, and let them go in. And if somebody came out, you'd turn lights on the car or somehow signal that somebody's coming. And they did, roll the yard and so forth. And, well, parents being like they are, they figured it out real quick. We try not to get caught. Went home. Of course, the next morning, I guess parents had talked or whatever, they figured it out. I get brought in, you know, the face of parents, and, you know, they confront me with it. What do we know about this yard rolling? Nothing. Well, of course, that's what I said initially. So Eventually, the whole story came out. But I didn't throw any toilet paper. I didn't roll anybody's yard. I just drove the car. Don't matter. You get right over there and clean it up with the rest of the guys. Okay? So and we're taught those types of things growing up from our parents. That if you let your friends talk you into doing certain things, you suffer the same consequences that they do. Okay, that's what this is. That's what this concept is. Because a defendant can be criminally responsible as a party to an offense. And again, these crimes, felony murder, first-degree murder, rape, and so forth, if they were committed by the defendant's own conduct, by the conduct for another for which he's criminally responsible, or by both. And each party may be charged. That's what this concept is. And if it's conduct committed by another, it's when they act with the intent to promote or assist the commission of an offense, and they aid another person to commit an offense. There are other ways to do it, but for purposes of this case, that's what we're talking about. And part of that definition, a defendant is criminally responsible for an offense can be found guilty not only that offense, but for any other offense committed by another, if you find beyond a reasonable doubt that the other offense or offenses were the natural and probable consequences of the original offense for which the defendant is found criminally responsible, and we prove all the evidence. Now, the distinction here is when we're talking about the felony murder counts, and that's murder and perpetration of these felonies, this rule doesn't apply. Because there's no requirement that the killing in that situation be foreseeable in order to hold a defendant criminally responsible. Only that they intend to commit a theft, robbery, kidnapping, or rape. So another key part of this instruction, you may take into consideration any evidence offered to show that this defendant attempted to thwart or withdraw from any of the offenses that followed the original offenses. And of course, what they're talking, the original offense obviously is the theft or the robbery, and we're looking at what he did after that to see if he attempted to thwart anything else or withdrew from what was going on. That's what that's talking about. This is critical language as well, because I know Mr. Frazier is going to stand up and argue. Well, you know, even if you do believe George Thomas, what about all this stuff that happened with Shannon Christian after he was supposedly gone? It is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. The encouragement of the principal offender is sufficient. Mere presence is not. Okay? Got two types of murder: intentional premeditated murder and felony murder in the state of Tennessee. They're all both called first-degree murder. Felony murder of Chris Newsom, we're talking about this defendant or one for whom this defendant is criminally responsible unlawfully killed Chris Newsom. And the same for Shannon Christian. The important thing to remember is felony murder does not require us to prove that he intended to kill anybody, or that anybody intended to kill anybody for that matter. Only that they intended to commit the felony crime that ultimately led to the death. And the judge will tell you that killing may precede, coincide with, or follow these crimes and still be considered as the perpetration of them, as long as there's a connection in time, place, and continuity of action. Now, let's talk about continuity of action. This house on Chippen Street, we know, I'm giving the benefit of some doubt, Chris was kidnapped at approximately 10 p.m. He was shot at 1:45 a.m., 3 hours and 45 minutes later. Raped 1 to 2 hours before the fatal shot. Part of Miss Christian, she was kidnapped about 10. Died late Monday morning or early Monday afternoon, according to Dr. Delusnik. She was raped repeatedly before being placed in that garbage can. So she was held at least 36 hours before she died. This language is critical when one enters into a scheme to commit one of these crimes and death ensues. All defendants are responsible, regardless of who actually committed the killing. Okay? Intentional premeditated murder for 2 counts. The judge will instruct you what intentionally is. Obviously, they were intentionally killed. A premeditated act is one done after the exercise of reflection and judgment. It is not necessary that that amount of time be any definite period of time. Now, running through all these definitions, I believe, is the concept of choices. And that's what this case is about. What choices this defendant made, what choices his co-defendants made, and what were the consequences of those choices. This defendant, when he found out what these guys were up to, he had a choice. He could try to warn it, hey guys, don't do this. Don't go steal that car. Under this proof, his response to that was, you need a ride? I've got this Sunbird. You want to go to Washington Ridge Apartment several miles away? Hop in. I mean, we don't have to prove that's what he said, but that's what this proof suggests. He provided transportation to his co-defendants to commit. Maybe he thought it was just going to be a car theft. But under natural and probable consequences, as the illustration was last Monday, it's like dominoes. Once you commit one crime, it's natural that the others fall in place as well. So he had a choice at that point in time. Now, do I want to be a part of it, or do I not want to be a part of it? He could have said, no thanks, see you. I ain't having a part of that. But the proof strongly suggests he provided them transportation. He set the wheels in motion, literally and figuratively, for all this to happen. Now, his buddies, Mr. Davidson and Mr. Collins, they were apparently dead set on getting a car by whatever means necessary. And if Mr. Boyd said no thanks, don't want any part of it, chances are they would have gotten it some other way. May not have been these 2 innocent kids. May have been somebody else, because they were intent on doing something bad. This defendant took them to Washington Ridge Apartments, we say under this proof. So he didn't thwart or withdraw. He didn't say he took them over. So the scheme initially was to commit theft. And of course, we know that death ultimately ensued, so he's guilty of felony murder in the perpetration of theft. So on January 6th of 2007, we got this team of thieves going to get a car. And again, they don't want to do the hard work and hot wire or something like that. They want to do it by force. They won't be able to drive that car immediately when they find one they like. So it's a team of them. We talked about that team concept last Monday. Now, when you're a part of a team, you not only reap the benefits of being part of the team, but you're also responsible for things that the team does. Whether they're good things or bad things, you're responsible. This team of thieves encountered these 2 young folks at Washington Ridge Apartments inside that good-looking car, and they forced them into that car. They still had choices. They still could have made different choices. Okay? Here's the car. They've got the keys. We can get that car because they've got the keys. Maybe even been running. We don't know. Why don't we just get them out, or don't let them get in, whichever the case may be, and take their car, because that's what we want, is their car. That's all we got to do, is just get them out of it. We've got a car. They had a choice to thwart or stop or withdraw from anything further at that point in time. They go this way or that way with their choices. They can go a proper way or an illegal way. They took the illegal choice. And they elevated. They did not thwart or withdraw at that point. They became a team of robbers at that point. And we know they had guns. So they decided to use force, use guns, to take possession of this car and to take possession of these kids. Take the car. What you got to take these kids for? Why do you have to do that? take the car. They had other choices. Now they've got the car, they've got the kids. Now what are we going to do with it? At that point, they could have afforded or withdrawn from anything further. They could have driven that car away, even with those kids in the car, and dropped them off at BP or someplace on Cherry Street. We don't want to, we just need the car, we don't need the kids. That was a choice they had to take and make. What are we going to do with it? They chose not to drop them off. They chose to bind them, to gag them, whether it took place in the car, probably so, we don't know, and take them to Chicken Street. So that team of thieves turned team of robbers, now turned into a team of kidnappers as well. And that team of kidnappers still had choices. And you got to understand, ladies and gentlemen, under this concept of criminal responsibility and natural and probable consequences, all of these crimes, once they decide to take these kids, everything that happened to them after that, not only natural and probable, natural and inevitable, is part of what happened to these kids later on. Again, at every turn, and think of premeditation. I mean, we may give an example last week. Think of premeditation and the ability to think and process information and then make a decision, make a choice. They're in this car. They've got these kids, maybe them, maybe not them, whatever. But think about, they can stop it all. They can stop all this. And figuratively speaking, I'm sure they passed through stop signs or red lights or not stop. They didn't stop. They kept on going. They kept on going right back to 2316 Chittenden Street, and it's there for just unimaginable reasons. They decided to brutalize these kids, rape these kids, and given the time frame, and Chris, relatively speaking, in terms of these crimes, Chris died fairly quick, 3 hours and 45 minutes approximately after he was kidnapped. He was raped for that period of time. These guys were just so intent on committing bad crimes, brutalizing people, or perhaps Chris, in his effort to fight it off, he suffered a rape because he was going to die, and he suffered a rape in the process, a brutal rape with some object in all likelihood. And he was taken, man, barefoot, back in the shoes that Davidson ended up having over the Reynolds for wearing the sizes too small. But he was raped. Maybe he was being punished for trying to fight back. Don't know. It's one of those pieces we don't know. Maybe it's better we don't know. But he was brutalized, tied up, they get bound, gagged, loaded back up in that SUV. You know he knew where he was going. He was going to his death, and that's where they took him. The railroad tracks a short distance away from that house. Leaned over, shot him, put a bullet in the back of his head. Dead. And what else they did? They set him on fire. This defendant shot him in the back of his head. This defendant set him on fire after. This defendant drove that SUV back to Chittenden Street. This defendant told Mr. Davidson, it's done. After they raped these kids, they still had choices. They could have chosen not to kill them. Release them alive, brutally scarred for the rest of their lives, granted, but they'd still be alive. They had the choice to do that or not do that. And the choice they took was, don't do that. Kill them. They're witnesses to brutal crimes that we have committed. We cannot allow them to live. And that's the choice they made. That's the choice that this team of thieves, turned robbers, turned kidnappers, turned rapists made. They did not fork or withdraw from that scheme, that plan. And they became a team of murderers. As I mentioned, natural problem consequences just predict what was going to happen to these kids from the get-go. The dominoes started falling. The car theft, leading to the robbery, leading to the kidnapping, leading to the rape, leading to the murder. The illustration being, you got these dominoes stacked up once they start falling. And think about it, I'm sure you're all familiar with this, and especially in younger age kids, this concept of peer pressure. Once you join the team, there is so much pressure to stay on the team and do team activities. Peer pressure comes into play, even at the older adult level, I'm sure. But once you're part of the team, unless you thwart or withdraw from that team, then under the law, you're responsible for everything the team does. That's, in a nutshell, what this is all about. But for Mr. Floyd and his borrowed Sunbird, all of these guys over to Washington Ridge Apartments, but for him, it's another way to analyze this concept. If it hadn't been for him, granted, they've been different victims perhaps, Shannon and Chris would not have suffered what they suffered, and they would not have been killed. He started it. He was there at the beginning. He was there throughout some of it, most of it. Even if he was gone from some of it, he's still responsible under this law. I've done my math right, and granted, I need a calculator. It's been 4,600 days since these crimes happened, as of today. Okay. I started doing 365 days a year, started adding it up, and wait a minute, we had some leap years in there. That's how long it's been. So I had to add some days to it. 4,595 days is how long it's been since George Thomas told Sheriff Hutchison that this defendant marched Chris Newsom into that house on 2316 Chipman Street. Now, I think we explained this to you early on. George Thomas was charged with these crimes. He's been convicted of these crimes. But just because he told Sheriff Hutchison and former Sheriff Jones and former Sheriff Hutchison, I guess is technically right, just because he told them 5 days after this happened that Eric Boyd was heavily involved in it, did all these things, we couldn't use that as long as Mr. Thomas was charged. We can't put Mr. Thomas's statement in against Mr. Boyd until Mr. Thomas gave us permission to do that. And that's why Mr. Thomas was here, to give you a couple more pieces of this puzzle, if you will, to give you a couple more details about what happened. All the details we'll never know, as I said, we will never know. But that's why we weren't here 12 years ago with Mr. Thomas sitting up there telling you what happened, because he was charged. We can't use his statement against anybody else until he gives us permission to do so, and that's what he did. He answered questions directly. He answered questions from Mr. Frazier and from the state without hesitation. And as Sheriff Jones, former Sheriff Jones told you, he did the same thing 12 years ago when he interviewed. Now, I'm not embracing Mr. Thomas whatsoever. He's a convicted murderer, okay? But I suggest to you, when he testified under oath, the same oath y'all did, that you have the right to believe the key elements of his testimony. Did he tell us it? Did he hold back? Sure, he's still holding back. We know that. I'm not going to say he's not. But the key subject matters of his testimony had been corroborated by these other witnesses. Xavier Jenkins, Adrian Mathis, cell phone records, all of those things corroborate Mr. Thomas. And Mr. Thomas corroborates them. That's the way this theory of corroboration works when you evaluate this testimony. These kids didn't deserve that, you know that. But again, but for this defendant, see right there. Thank you.